This is how you sell a property in Texas if it's in an estate, whether you're the executor or you are the administrator of the estate. So first, executor, what's the difference between that and the administrator? The main difference is the executor is someone who has been chosen by the deceased person. So that name is written into the will. And that executor is going to follow the will exactly as it is written. You can't do anything that's not written in the will exactly. An administrator is chosen by a probate judge. So this is when there's a will that's not valid or there is no will in place. And an administrator, they're going to follow the state law explicitly. So let's jump into this. An independent administration. This is really common when there's a will in place or if all the heirs agree to this person being the independent administrator. The dependent administration, this is a fully, it's more involved with the courts. The courts and the law say what to do and when to do it. So this is a dependent administration. So let's go with the IA, the independent administration. This occurs when the will explicitly grants independent powers or all beneficiaries agree to it. So this is when there's minimal court intervention. This is what happens when you've done your part and you've set up a will the right way before you pass away. So step one, if this is you, if you're in an independent administration, this is what you're going to need to do to legally sell the real estate within that estate. So number one, you've got to obtain your letters of testamentary and verify the power of sale. So you have to formally qualify before the probate court by taking an oath, and then the court will issue your letters of testamentary for the executors or letters of administration for the administrator. So this is a very key step one when getting ready to sell property within an estate. So the next thing you're going to do is you've got to verify that you've got the power of sale. If it is explicitly written in the will, and if it's not, then the court grants via heir consent. Basically, all the heirs are going to consent to the sale. You have the immediate right to sell. If the will does not grant this power, you can still sell, but here's the caveat. It's required only if it's required to pay off debts that the estate has, or if all the heirs sign the deed. So that's the only way you can do it without having this first, okay? So step two for the independent administration. You have to establish fair market value and list the property. And this is where I see people make mistakes all the time. You have to have an appraisal so it fulfills your fiduciary duties as the beneficiary. So what the court wants is an appraisal that's issued by a licensed appraiser. So don't skip over that step. And then after that, you can hire your realtor. So here are some things that I want to say about that. You're going to want to interview more than one realtor and ask them questions, not just questions about what they're going to do to sell your property, but what's their experience working with an estate. And then look at the standard operating procedures. Okay, so step number three, you're going to execute the contract, close, and then distribute the funds. So this is something you don't want to skip. As an independent administrator, you have the authority to sign the purchase contract and close the sale without asking for the judge's permission, which is huge. That's why it's so important to get these things set up in advance. The title company, they're going to require a copy of your letters of testamentary. They're going to need that. Ideally, have all that information ready when you meet with the realtor so that they can get that sent to the title company that they normally work with. And then once it closes, the funds are going to the estate bank account first. This is where people get twisted sometimes. They sign, they close, they think the money's coming to them. If you're in a jam or a family member's in a jam, remember to set expectations up early. The money's going to pay off all the debts by the estate first, mortgages, taxes, tax returns, things like that that are owed by the estate. And then after that, then you guys can get dispersed the funds. So now let's talk about the dependent administration. You have to file an application to sell, and you've also got to get the court-approved appraisal. So that's step number one with the dependent administration. So you have to formally apply for the sale of real estate with the probate court. This is a big thing right here. And then you've got to file within that application. It's going to talk about the condition of the property, any debts that are owed by the estate, and also why does this benefit the estate. They're going to want to know why would it benefit the estate to sell the property versus keeping it. Simultaneously, you're going to get the court-approved appraisal. So a licensed appraiser in the state of Texas can give you that. And then step number two here, you're going to secure an offer just like you would normally. but it's subject to court approval. That offer has to be approved by the court first. As a dependent administrator, you can sign, but you have to have a contingency clause stating the sale is subject to court approval. That's why it's important to work with a realtor who understands this, so you're not missing out this legal stipulation of having that contingency clause. And then step number 3 in the dependent administration, you're going to file and report the sale and attend a confirmation hearing. This is very, very important when you have a dependent administration. So within 30 days of signing the offer, you file the report of sale with the court. The judge is going to have a hearing and rule that the transaction is a fair sale, meaning it's within the 90% threshold, and then they issue a decree conforming the sale. Then you can get to the closing table. So if this is something that's been helpful for you, or you want more help figuring this out, send me a private message here. I work with these kind of deals all the time, and I can walk with you through this process.